Every year, organizations send thousands of hours of sensitive audio to transcription services without knowing where that audio actually ends up. It might travel through servers in another country. It might be processed by contractors with no background checks. It might sit in a cloud environment that falls outside the legal jurisdiction of the United States. For most industries, that is not a minor administrative concern. That is a compliance failure waiting to happen. This is the core problem with how transcription services have evolved. The rise of automated platforms and offshore outsourcing has made transcription faster and cheaper on paper. But for organizations handling sensitive material, cheaper often means exposed. A police department uploading interview recordings. A hospital dictating patient records. A law firm transcribing depositions. These are not generic data transfers. They carry legal, regulatory, and ethical obligations that do not disappear just because a vendor promised a fast turnaround. Data sovereignty matters here in a very practical way. When audio or transcript data crosses international borders, the legal protections that govern it become complicated or disappear entirely. HIPAA, CJIS, attorney-client privilege, FERPA protections for academic records, these frameworks are built around U.S. legal jurisdiction. They assume the data stays within reach of U.S. law. The moment it leaves, that assumption breaks down. So, who is carrying this risk right now? It is the procurement officer evaluating transcription vendors for a county sheriff's office. It is the compliance manager at a regional hospital making sure vendor contracts satisfy HIPAA business associate requirements. It is the legal administrator at a mid-sized firm wondering whether the automated platform they signed up for actually keeps transcripts confidential. It is the research director at a university handling IRB-approved interview data that cannot be shared outside defined parameters. These professionals are not just buying a service, they are accepting accountability for how sensitive information is handled. When something goes wrong, the vendor's terms of service do not protect them. They need a transcription partner who operates under the same legal framework they do. Consider 4 scenarios where this becomes critical. A law enforcement agency is transcribing recorded interviews from an ongoing investigation. Chain of custody matters. The transcripts may become evidence. Any question about where that audio was processed or who accessed it can create problems in court. A medical provider needs transcription for clinical documentation. Under HIPAA, any vendor touching protected health information must qualify as a business associate and meet specific security requirements. An offshore platform or automated service may not meet those requirements at all. A corporate legal team is preparing for litigation and needs deposition recordings transcribed with precision. A single misheard word can change meaning, and the transcript must be defensible if challenged. And an academic institution is transcribing qualitative research interviews with human subjects. Those subjects consented under specific IRB conditions. The institution is responsible for honoring those conditions across every vendor in the chain. Each of these situations requires more than a fast transcript. They require a managed process with verifiable accountability. This is where Ditto Transcripts operates differently. Ditto Transcripts is a US-based, full-service transcription company. Every project is handled entirely within the United States by human transcriptionists under a managed service model. There is no offshore handoff. There is no automated AI pass with a human spot check. Ditto Transcripts employs staff who pass fingerprint-based criminal background checks, which is a specific requirement for CJIS compliance that most transcription vendors cannot meet. Ditto Transcripts maintains compliance with both CJIS, the Criminal Justice Information Services Security Policy, and HIPAA, the Health Insurance Portability and Accountability Act. These are not checkbox claims. They reflect the actual operational structure of how Ditto Transcripts handles data. For law enforcement agencies, CJIS compliance means the people processing sensitive criminal justice information have been vetted at the same level required for anyone accessing those systems. For healthcare clients, HIPAA compliance means Ditto Transcripts can serve as a qualified business associate with appropriate data handling standards in place. Ditto Transcripts serves legal, law enforcement, medical, academic, and general business clients. The full-service model means a client submits work and receives a finished, human-verified transcript, not a raw output that requires internal review and correction. That consistency matters when transcripts are going into court records, medical files, or published research. What does this mean in practice for the people making these decisions? The procurement officer can include Ditto Transcripts in a compliant vendor framework without needing to file exceptions or seek legal review of offshore data flows. The compliance manager gets documentation that satisfies HIPAA audit requirements. The law firm gets transcripts produced by vetted professionals operating under U.S. jurisdiction, defensible if challenged. The research director gets a vendor who fits within IRB-approved data handling parameters. The alternative, sending sensitive audio to a platform that processes it with unverifiable methods or routes it through international infrastructure, is not a trade-off worth making just for a lower line-item cost. Organizations that handle sensitive work need a transcription partner who is accountable in the same way they are. That is what Ditto Transcripts is built to be. Learn more and start a project at www.dittotranscripts.com.